Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we're going to take a look at Forrest Gump's famous phrase about stupid is as stupid does in the context of the Kouri Richins case, so stay tuned. Let's suppose that you have come to the sudden realization in your marriage that you absolutely, positively hate your spouse. He or she won't do what you want them to do. They won't buy a house you want. They won't support you in a business endeavor or whatever it is that really just turns your crank. You are so mad at them that you want to kill them. But here's the thing, you don't want to go to jail afterwards. I mean, that'd be icky, right? So you have to really plan this out. And of course, the way to do that is to do internet searches. But what you don't do is you don't do internet searches on your phone. Because the very first thing that law enforcement goes after a crime is anybody they think might be a suspect. They go after their phones and their devices. That's the first thing they do. Generally, whenever there is a death of someone that is believed to be a homicide, the very first thing that happens is they look at people close to the decedent. In other words, the spouse, in some cases the children, and in other cases the parents. The people who are closest to them are most often where the suspect pool starts. Now, if they can be easily eliminated, then that's great. But if they can't, then the investigation goes a little deeper. And like I said, one of the first things they ask for in terms of seizing with a search warrant, is the phone and any computers that you have. So it's not real smart to do internet searches on your phone or on your home computer. If you're going to do that, you need to go to the public library and, probably wear, something that covers your face like a mask and a hat pulled down low so that you're not easily recognized and people can't go show the police where they saw you doing the internet searches, because a lot of those computers hold that data for years and years. So that's my assertion anyway. If you're going to do something evil like this, and you don't want to get caught, you ought to at least have enough common sense not to do any kind of internet search from your home. But let's take a look now at the searches that Kouri Richins did from her home on her cell phone. These are the searches. What is a lethal dose of fentanyl? Okay, her husband died from a lethal dose of fentanyl. Well, gosh, that wouldn't be suspicious, would it? Luxury prisons for the rich in America. Well, it's nice to know she was planning her accommodations. Death certificate says pending. Will life insurance still pay? Oh, my goodness. Again, if you were drawing a giant poster board that said this, you couldn't draw it any more clearly than with these searches. Can cops force you to do a lie detector test? The answer to that, by the way, is no. And of course, it's useless because the only thing it does is it makes it easier for them to bluff you or lie to you and say, hey, it shows deception. How to permanently delete information from an iPhone remotely. Well, that one didn't work out well for her either. So all of these things indicate both a lack of sophistication as well as a lack of having watched any of the forensic TV shows, the Forensic Files, the FBI Files, even a couple of episodes of CSI Miami or CSI Las Vegas would have given you enough background to know that the way police catch people who do things like this is they look for their internet search histories. And so this particular case is going to be won, I think, by the prosecution on just that search history alone. As you probably know, The death here was caused by a overdose of fentanyl, and the theory is that it was delivered in a Moscow Mule, which the decedent had a couple of drinks from before he turned in and did the old forever sleep. I went and looked at the recipe for a Moscow Mule, and oddly enough, it doesn't say anything about adding fentanyl to it. So, since she was the one who made the Moscow Mule, it is at least inferable that if there was fentanyl put into it, it was probably put in by her. Although, obviously, the state has to prove that, and I think probably they will. Let's take a look real quickly here at the video of the forensic expert who did the download on the phone and some of the information that he found. We'll start by looking at the movement issue, the movement of the phone and how it was moved, and then we'll move on to the internet searches after that. I also want to point out that I had to take out the long pauses in here when the prosecutor was trying to think of the next question. So it may appear a little bit choppy, but trust me, I probably saved you a good minute and a half.
Did you analyze forensic extractions of an iPhone belonging to the defendant that was seized April 13th of 2022?
I did.
Does it contain digital information pertaining to the night of March 3rd and into the morning of March 4th, 2022?
It does.
What does that phone show? Well, let me ask it this way. What is the last time that that phone is used on March 3rd of 2022?
The last activity reported on the defendant's phone is an activity device movement at 22:33 hours or 10:33 p.m. on March 3rd.
When was the next time that that phone was used?
The phone was inactive and then ultimately unlocked at 3:07 a.m. on March 4th, 2022.
Was there anything that happened between those two timeframes?
On that device?
On
No.
that device?
No.
Does the extraction of that phone indicate if it was moved in that time frame?
It does.
And how are you able to tell that?
Through the download, in this case we use Cellbrite for the download. In the download, it gives an activity, like a connected device activity movement. Usually that's an indicator of another connected device, such as a tablet or a smartwatch or something of that nature. Those two devices will communicate with each other and report potential movement of the phone through that application.
Was there anything significant that occurred at 3:22 hours on March 4th?
At 3:22, yes, a 911 call was made.
So between the time that the phone is used at 3:07 that morning and 3:22, is there any activity that could be seen from the download?
There is.
What is that?
At 3:07, the device is unlocked. At 3:08 a.m., the device reports some type of movement. Either the device itself or a connected device is moving. At 3:12, the phone was unlocked. At 3:16, the phone was unlocked again. At 3:19, the phone was unlocked again, potentially twice. There was movement again at 3:21, and then at 3:22, the 911 call was made.
Ignoring for a moment the search history issue, look at what they've done here. The phone is used to track her movements internally in the house on the night that the death occurred. And that's a function of people not understanding how their smartwatch communicates with their phone. Because if they understood that, they would know that the phone recognizes movement on those devices. It syncs with those devices periodically, and those kinds of movements and that sort of thing are recorded. And with it, you can, and the jury, the prosecution and the jury can make reasonable inferences that if one of those devices is moving, somebody is doing something. So this is fairly important testimony, and you'll hear it again at trial.
Did you analyze a forensic extraction of a second iPhone belonging to the defendant that was seized in May of 2023?
Yes.
When did activity begin on that phone?
The activity on that phone started shortly after her original phone was seized in April of 2022.
Were you able to observe internet searches on that phone?
Yes,
And did you create a PowerPoint of some of those searches?
I did.
And just for the court and council's reference, this is docket item 141. Were you able to tell when those searches were done?
Yes.
How did you do that?
There is a date and time stamp of the history, the web history. So for instance, if you visit a website and you click through it using your device, it will report what date and time that you did that connected to that website.
I see. On April 18th of 2022, did the phone access an internet site of an article entitled "What Happens to Deleted Messages"?
Yes,
On May 10th of 2022, did that phone access a site for an article entitled "How Do Police and Forensic Analysts Recover Deleted Data from Phones"?
yes,
Did that phone was a query placed in that phone, quote, "Can cops, period, uncover deleted, period, messages, iPhone," close quote?
yes,
Did that phone search, quote, "How to, period, permanently delete information from an iPhone remotely," close quote?
yes,
Did that phone search, quote, "Luxury prisons for the rich in America"?
it did.
Did that phone search, quote, "If someone is poisoned, what does it go down on the death certificate as," close quote?
Yes.
Were you able to tell when those things were searched?
The search themselves, there was no date and time reported for the individual search. However, I found corresponding websites to those searches that did have the dates and times in the web history.
And was there a certain time frame that these searches were made?
They were.
Can you describe what that was?
It was typically between, well, shortly after her original phone was seized. So from April, middle of April of 2022 through, memory serves me right, about August of 2022 off and on.
Thank you.
Well, that was pretty impressive. The guy operated from memory about what was on the phone, the times, the dates, that sort of thing. That's a guy that he's a rock star as far as being able to testify. He obviously knew what questions were coming, he knew what they were, and he knew the answers to them without having to look at notes or anything like that. When you can do that at trial, you come across as just a bona fide expert. It really lends credibility to you. And so at the end of the day here, this was a huge win for the prosecution. Now, as you may know, this was a bond hearing, or I think what in Utah they call a detention hearing. They were trying to determine if there was enough evidence or any sort of evidence that she might be a danger to herself and others, such that it would be necessary to detain her permanently behind bars until after she goes to trial. And in doing so, they came up with all this evidence that pointed directly to her guilt, and then one of the decedent's sisters testified that she punched and attacked her. And I think it made it pretty easy for the judge to come back and say, "No, I'm sorry, we are not letting you out on bail." Well, that's what I have for you today. I know it's probably not as long as some of the other videos I've done recently, but hopefully it is succinct and to the point, and you've enjoyed it. If you have any questions, leave them in the comments down below. Like, share, subscribe, you know all the things we ask you to do. And if you would, when you have the opportunity today, go out of your way and do something kind for someone. Have a great day, and I'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.
you.